Assalamu alaikum, welcome back. We are discussing immigration matters. I have an immigration specialist who's been practicing immigration for 8 years, Yomi Yusuf. Thank you for coming and joining us today to assist us with immigration questions.
Thank you for having me.
Good. Right, viewers, you can call in and ask your questions, inshallah in English, and I'll put them to Yomi to sort of give us his guidance on the area and the question that you've raised. Before we went on the break, there was a question in relation to entrepreneur and the financial requirements, etc. And the caller asked about English, and we said it's a point-based system, so they have to get the points for that. I just wanted you to explain the difference between point-based system and a non-point-based system. I mean, is point-based system if it's to do with business? How does it work?
Well, the points-based system was actually introduced in bits and pieces starting from September, October 2008. And I think what they did was decided to introduce these rules or the points to make it a sort of fairer system to a lot of prospective applicants. Prior to the points-based system, there's so many other routes that people could apply, but I think people felt that their applications were somewhat unfairly judged or assessed, and this led to numerous refusals. The points-based system was actually adopted from Australia-style immigration system, and what it set to introduce was prospective applicants would be able to sit down and then determine whether they met the points prior to making the application themselves, so that they knew themselves what the likely outcome would be.
So they could judge whether they meet the requirements, yes, and whether they would succeed or not.
And there were no issues of unfairness or grey areas. Everything was either black or white. So if you had the English language test,
so they either gave you the 10 points or not.
Yes, yes, and you would know why.
Okay. Viewers, you can call in. Let's take the next caller. Assalamu alaikum. What's your name? Where are you calling from?
Walaikum assalam. I'm calling from Birmingham. Actually, I have a question regarding immigration matter. I'm on Tier 2 journal visa, and I've got chef code 5434. My 5 years are going to complete in December this year, so I am going to apply for ILR in November. At the moment, my sponsor's license is suspended. So my first question is, can I apply for ILR while the license of my sponsor is suspended? The second question is salary. What's the requirement? Because currently I am on 20,750 per year. So what is the requirement if I'm going to apply for ILR? What would be the salary requirement? And the letter that I need from my sponsor, what should be the contents of that letter? Thank you. That's it.
Okay, thank you very much for that. So you've heard the question. The lady's on a Tier 2. First difficulty is her sponsor has been suspended.
Oh dear.
She is going to complete 5 years, not right now, but maybe another 6 months or so. And third question is how much money, income should be sort of put forward for her to succeed. And I think she asked about the contact details or the information relating to that. The money, obviously we won't really give out numbers here per se. That's something you look up and see. But in terms of the sponsor being suspended, does the application, does the counting, the time, the 5 years, does it stop instantly? Or would they get like a 60-day, if you were a student, you get a 60-day grace period to find an alternative?
Yes.
How does it work on Tier 2?
Well, the first stage is to, I don't know why the sponsor's license would have been refused or reviewed or suspended. But ideally, if you're a sponsored migrant or that Tier 2, I know one of the crucial requirements is to have an existing sponsor who will issue you a certificate of sponsorship with which you will then use to obtain a visa, which then allows you to come to the UK. Aside from the certificate of sponsorship, the job offer also has to be within the 20,000 earmark. So if you do not have a sponsor for a certain period within that 5-year period, then obviously this would count towards your application. Like you could be refused for
indefinite leave to remain.
Indefinite leave to remain, because the requirement is to have been sponsored throughout the entire period. Throughout the entire period of the 5-year period. If the sponsor's license has been suspended, there would be a very good reason why the sponsor's license has been suspended.
So the first thing is we need to identify what was the reason, and does that reason affect the applicant, yes, in this case.
Yes.
And the second question is, can the applicant then find an alternative sponsor and continue their 5-year period? In relation to the finances, obviously, we want to address that. And in relation to the contact details or the address details, I don't think we can answer that.
Contact details of whom?
I think, let's say, for example, your employer has been suspended or the business has ceased, then obviously putting their contact details may not get you anywhere. If I understood the question correctly.
The contact details of the sponsor?
The sponsor.
In the application form?
Mm-hmm.
Well, I don't think that that's going to make a significant difference, because what the Home Office officer wants to see is that, A, you have an existing sponsor, and that your sponsor has complied with the requirements and obligations as a sponsor, and you also, you've complied with your requirements as a sponsored migrant. So if you do not fulfill those two requirements, it will have an effect ultimately on your application for permanent residence. So I think the first question would be why the sponsor's license was suspended, and if it is it a temporary suspension or permanent suspension, and is it something that can be rectified? But if not, then my advice would be that she should start to look for an alternative sponsor. But then again, in order to find an alternative sponsor, she has to find a sponsor who's willing to take her on. And I know that these matters aren't as straightforward as they may appear, because most sponsors will only take you on if you have something to offer them, because they would have to go through the process of applying for, well, it could be an existing sponsor already, someone who has already an existing sponsorship license. They would have to issue you another certificate, and then you'd have to switch over to their employment. So there's a bit of a difficulty.
There's a bit of difficulty.
Yes.
There'll be sort of discontinuity, and that can raise quite a few issues.
It certainly can.
And of course, just here, as we can't give straight, clear answers, I think even the Home Office, when it comes to these things, it does confuse matters, because you don't have what you're supposed to have.
Yes.
You have a mix and match, and it does cause confusion. So viewer, my advice would be, obviously we don't know what the reasons for suspension for the sponsor was. But it does introduce difficulty, and you need to be on top of your case. Perhaps go to somebody local to you and give them a full disclosure, and see if the sponsor can fix whatever issues they're having, because I think that's where the difficulty lies. Because if your sponsor is back on board, everything is fine, then inshallah, once you complete 5 years, you can apply for indefinite, and provided you meet all the other requirements, there shouldn't be any problem. Usually we have problems like this with universities or colleges being suspended, and then the students having the 60-day letter to find a new sponsor or new college, and then the difficulties associated with that. And the Home Office, they want to be sympathetic, they want to give a bit of room to maneuver, but it does sort of put if you like, it takes things off track, and you don't know where it may lead you. And so it can get complicated. In terms of areas you practice, has there been any recent changes that we can sort of discuss something you've done recently that you found interesting? Or, I mean, for example, myself, the immigration health surcharge, which has been around since April this year, yes, it has literally doubled or tripled some people's expenses.
Cost of applications, yes.
And if you were getting lawyers to assist you, the portion that lawyers were taking has now been consumed by this immigration health surcharge. So it's actually creating difficulty on top of what was already difficult and quite expensive applications to make.
I totally agree. This is an area that is bringing upon a lot of difficulty upon the prospective clients, because in addition to the application fees and the legal fees, then they now have to also set aside some fees for the health surcharge. And I can understand why it was introduced. I think it's actually laudable of the Home Office to have introduced that, because then it reduces the pressure on the NHS, so to speak, and they're able to maybe regulate it better or fund it better.
I think it's too blunt. I mean, some people who are born here, they already have NHS, they can already access NHS, or some people have private medical insurance. But from my experience, Home Office is not interested. They just want that money and tick a box. But I'll come to you for more. Assalamu alaikum. What's your name? Where are you calling from?
Assalamu alaikum.
Walaikum assalam. What's your question?
भाई मेरा एक क्वेश्चन था कि मैं उर्दू में बात कर सकता?
English is better because our guest doesn't speak Urdu, but inshallah.
Can you understand Urdu, brother?
I can, but if you can tell me in English, it's better for the guest, so I don't have to translate.
Okay. The question was, I've got one friend.
Mm-hmm.
Yeah. Hello?
Yeah, go on. Say your question. I'm hearing it.
Yeah. I've got a friend. He's recently, he was in sign, in Home Office sign, okay? And recently he missed 2 sign. Hello?
Yeah, go on.
Can you? they sent me a letter. They said they're gonna fine him like £5,000 or 6 month prison. Okay, because he don't want to go for sign. He want to go back his own country. So at this point, they're gonna give him like 6 month prison or £5,000.
Okay, we've understood your question, inshallah. So we'll address that. Okay.
Can you answer, please?
We will answer, inshallah.
Okay.
So Yomi, we have somebody who was given routine signatures. They had to go and sign, say back at house or something where they have to sign. He doesn't want to sign, but he has decided to go back to his home country. So if someone decided they want to leave the UK, should they just go and sign and say, look, I want to go back, or how does going back work?
Okay, that's interesting. If someone is required to report at the Home Office, it could be for a variety of reasons, but mainly because they are subject to immigration control. So either they have an appeal pending or some other matter pending, or whether they've overstayed their visa or leave to remain in the UK. If that person decides that they've had enough and they wish to return, all they have to do is notify the Home Office of their intentions to return. Now, it is open to that person to determine how they wish to return. Now, I know that they can buy a ticket and inform the Home Office that they intend to return. If their passport is with the Home Office, then usually the Home Office would have your travel document or passport, so to speak, waiting for you at the airport on the date that you intend to depart. They would usually request for a copy of your ticket and other details, or traveling itinerary, just to ensure that you actually are intending to leave. And once you've sent that information to them, then they usually have your passport ready for you at the airport. If your passport is one that maybe it is expired and you can no longer travel on it, then you could approach your embassy in the UK to have your passport renewed or to reissue a new passport. If that is not possible, then you could apply for a travel document or an emergency travel certificate, which then allows you to depart the UK at your own expense and at your own pace.
What happens if you cannot afford the return ticket?
If you cannot afford the return ticket, then if you inform the Home Office that you intend to leave the UK, then it means that they may have to buy your ticket for you. Unfortunately, the implication of this is that you may be unable to return to the UK for a period of close to 5 years if they have to buy your ticket. Now, it's important to differentiate between being removed and a voluntary departure. Now, this is a voluntary departure. However, the applicant is unable to fund their return ticket, which means that it falls into the five-year non-return mark. The departure is when you're being removed and they have to pay for your ticket. But if you are saying, okay, I do intend and I would love to leave, but I'm unable to pay for my ticket, then the Home Office will provide your ticket for you. But the implication of this is that you're unable to return for a period of 5 years.
Okay. So, brother, if your friend does want to go back to his home country, he can, buy a ticket, say 2-3 weeks ahead, and then inform the Home Office that he wants to leave, and the Home Office could provide him with the documents that they were holding, perhaps, on his behalf. If he doesn't have valid documents at this point in time, then he needs to approach his local, his country's embassy in the UK and see if he can sort the paperwork out so that he's able to return home. If he doesn't return home on his own expense, then there are other implications which may mean that he comes back. Because if he returns on his own accord, there may still be reasons why the Home Office may refuse applications if he was to make future applications, because obviously he may have overstayed or some other issues have arisen. Let's take the next caller. Assalamu alaikum. What's your name? Where are you calling from? Assalamu alaikum. Can you hear us?
Hello?
Hello, yes. Can you hear us?
Hello?
Yes. Assalamu alaikum.
জি এটা স্টুডিও তো ইয়ে হরা না স্টুডিও তো দর্শন
না না হুমরা কইলাও কা
জি
আপনার প্রশ্ন কইলাও কা
না আমরা তো আমার ফুরিয়ে সাইডা থান স্টুডিওত মাত্তা
আচ্ছা আপনি লাইভ মাত্রাইছেন নানি
জি হয়
তো লাইভ মাত্রাই তো হোকা
আমরা তো দেখি আর টিভি দেখি আর না লাইভ মাত্তা আর করি
ও আচ্ছা কিছু ডিলে আছে 3-4 সেকেন্ড ডিলে তা আপনার কথা আমি শুনরাম বাট টেলিভিশন আইতে কিছু সময় ডিলে হয় আপনার প্রশ্ন কইলাও কা ইনশাআল্লাহ আমরা উত্তর দেব Okay, we were saying there is a delay, but there's usually a delay in when they ask the question and when it gets transmitted out. So we'll wait for the viewer to sort of fix that if you like, and then we'll turn back to the phone lines.
Okay.
Sometimes you get those questions where somebody has no money, they don't have their documents, Home Office is holding them, or Home Office has lost them, or something has happened. Now, if they approach their embassy, some embassies will not give them documents without a letter from the Home Office. So how can one go about getting the letter from the Home Office? Is there such a thing? Can you write to the Home Office, say, "Dear Home Office, I want to leave the UK, I have had enough. Can you give me a letter which I can give to my embassy?"
It's a bit of I found that it's a bit of a tricky situation, a sort of catch-20 situation, if you will.
So the Home Office wants you to leave. You've decided you're going to leave, but then still getting it to happen is quite tricky.
Yes, if you decided you went to leave and you needed a travel document, a passport, if you like, from your embassy, and you approached the embassy and your embassy have said that they will not issue you a passport because you do not have leave to remain in the UK, and you do not have the right to remain for any reasons, you do not have a valid reason to remain in the UK, one of the solutions that we've found that has worked in the past is if you made an application to the Home Office on one of the application forms for a discretionary leave to remain. This application is for people who do not fall under any of the immigration rules. These are outside the rules. It's called the discretionary leave application. Usually once you've made that application, you pay the Home Office fees and the IHT fees. The Home Office would write a letter to you within a couple of weeks after receiving the application to confirm receipt of that application. We usually call it a letter of acknowledgement. That letter of acknowledgement can be presented to your embassy, which then gives them some sort of relief, if you like, to issue some sort of document to you, which you can then use to depart the UK eventually if that's the route that you wanted to follow.
Okay. So I think the best thing to really say is that if you do intend to depart, speak to a lawyer nearby or an immigration consultant, and inshallah they will look at your case and perhaps advise you as to where to go from there. There are some charities as well that assist. Some charities even provide funding for people who have decided they want to leave the UK. Sometimes the Home Office letter comes with contact details for some organization that can provide finances and assistance if you do wish to sort of return home. Inshallah, we'll take the next caller, hoping the call's been fixed. Assalamu alaikum, what's your name? Where are you calling from? Hello, can you hear us? Assalamu alaikum, can you hear us?
I just called you about, I was asking you, like, if they're going to charge, like, £5,000 or,
Okay, so you're asking would they get fined, etc., right?
£5,000 or...
Okay, that's fine. Just building on that, so if someone's been asked to leave the UK, usually the Home Office writes down that they could prison you for 6 months and fine you for £5,000. That's usually more of a threat. I mean, if you have decided to leave, they wouldn't want to keep you in prison or fine you £5,000. But that is something they say, if you don't comply, or if you don't sort of do what we've asked you to do, then there is that risk. So it's just a risk factor, isn't it, if they choose to ignore the Home Office letter?
Yes, it is a risk factor in the sense that the Home Office can decide to execute that letter in the sense that if you're asked to leave the UK or you do not leave the UK and you are found to be in breach of not being in the UK for any reason at all, then they could decide to prosecute you in execution of the documents stating the reasons why you should have left the UK in the first place.
Okay, and obviously if they pick someone up, they may then put them in a detention center, wait for documents from the embassy if that's relevant, and then put them on a flight. So sort of an enforced removal,
yes,
which carries a 10-year ban. Am I correct in saying that?
Yes, that's a removal, a deportation, 10-year ban, yes, on re-entry.
So if they applied for any application apart from human rights related applications, it will automatically be refused because they were previously removed from the UK.
Yes, because they were in breach, this is the word, they were in breach of their previous leave to remain in the UK. They would fall automatically under Section 327B, which is refusals.
Okay, so they've stayed beyond their time, they shouldn't have, and they're in breach. And of course, if they do come on a spouse visa or whatever, get indefinite, then it will still have an impact as their previous bad behavior, if you can call it that.
Their previous immigration history will be taken into consideration. However, if they met the requirements under the spousal visa, because there's a human rights application, isn't it, then the application will be decided on sets of its own individual merit, regardless of the applicant's previous immigration history.
And when it comes to becoming British, that still has a role to play, because since about a year now, they check 10 years of immigration history, and if they find anything on that, then they could come back with a refusal. So they do 10-year checks.
Yes. Usually you can apply for British passport 12 months after you've been on indefinite leave to remain. But in order for you to be able to apply for your British nationality, there's certain factors that will be taken into consideration, and your character would be one of them, as well as your immigration history. So yes, if you're found to have been in breach for a certain period, then that could count against you, in which case the Home Office would, or the Nationality Department, would write to you to state that we have found that you have been in breach of your immigration stay in the UK during a certain period, and as such, because of that, we advise that you have to wait for another certain period, which would usually be advised in their letters to you.
So you make an application for nationality, they say, right, in the last 10 years you've breached it 7 years ago, so you need to wait another 10 years to have a 10-year clean history, and until then your application is likely to be refused.
Yes, they have said that in the past, yes.
They have said that in the past. Okay, viewers, we are discussing immigration law. Of course, you can write in to us via email, justlaw@iqra.tv. You can write on immigration, family, criminal, other matters. It's not a problem, inshallah. We'll go through the emails and respond accordingly. In terms of immigration matters, Yomi Yusuf has been assisting us. Thank you very much for doing that. What would you advise people who are watching and they've got some questions but they don't want to put it on TV? I always say write in or go to someone local to you where you have a consultant right in front of you. Some companies do free short consultations, right? So I think that's the advice I can give. We've got a very short period of time, so I won't be able to take any more comments. Viewers, Jazakumullah khair for watching the show. I did enjoy it today, inshallah. Do write to us on our email. Jazakallah khair for coming in.
Thank you.
So until next time, Assalamu alaikum wa rahmatullahi wa barakatuh.